Well, as we continue getting reaction about former President Jacob Zuma being granted medical parole, I'm joined now by legal expert Nthabiseng Dubazana, DA leader John Steenhuisen, and COPE spokesperson Dennis Bloem. Nthabiseng, good evening. Good to have you with us, John, as well as Nthabiseng Bloem. Nthabiseng, let's start with you. Let's talk about the interpretation of how to apply the law. Do you think this decision was applied correctly?
Well, when you look at the requirements that are set forth in order for a person to be considered for medical parole, we look at firstly whether their medical condition is such that they cannot be functional in a correctional facility, they cannot take care of themselves basically while under correctional supervision, or whether the medical staff at the correctional supervision cannot handle or cannot deal with the kind of illness, terminal or not, that the inmate has to deal with. And then thirdly, we need to look at whether the offender or the prisoner is likely to reoffend should they be placed under medical parole, and all those conditions that usually are looked at. It seems that when you look at that criteria, that Zuma falls within the ambit of that. When you look at the specific section that is at least in the media briefing that was set out, section 75, it also adds that the person should be serving a sentence of 12 months, or not more than 12 months, I beg your pardon. But currently, Nthabiseng, we know, is serving a sentence of 15 months. But also, when you look at the amendment of the Correctional Services Act under Section 79, it gives even in more greater detail what is required in order for a person to be considered for such. So the medical report must be extensive as to what exactly the person is suffering from, and why is it that when they are placed under the correctional services that they'll be in, that illness cannot be held or handled in that facility. So I'm assuming the report that was put together by the doctors of Nthabiseng for purposes of the trial that he's currently undergoing in Pietermaritzburg, PE I believe it is, sorry, then when you look at that report, it must have had sufficient information in it to therefore give the commissioner the impression that keeping him incarcerated under those medical conditions would not serve any justice for his health, and also perhaps it might lead to some sort of terminal illness going through, or perhaps death maybe at the end of the day. So the consideration was under that ambit, I believe. But then unfortunately, I think the issue of the 12 months imprisonment part is the one that will probably be a bone of contention for most people. But the majority of everything else that has to be considered for a person to be released under medical parole, it seems like was correctly dealt with.
The decision-making procedure itself and those who were involved, is that open for review, seeing that it was not necessarily a transparent process that was undergone?
Yes, the application would have been made by the state, my apologies, by the attorneys of Nthabiseng on his behalf, considering what he's going through. So if the state is in opposition of this, they have the right to oppose it and say that as a result of perhaps studying the medical reports that were submitted, considering that he did not undergo examination by the medical practitioners appointed by the state, they will only have the reports to rely on. If the medical practitioner that they hired or acquired to deal with this matter says that the information that is within the report is not sufficient enough for the accused or the prisoner to be, placed under medical parole, they have the right to review it and or put it under review and say that no, this person ought to go back. But then when you look at the case itself, Pietermaritzburg, I don't know if the state itself would have a leg to stand on in that review process, because it was done under the sentencing procedures that were handed down by the Constitutional Court. And it was the matter between the commission, the Zondo Commission versus Nthabiseng. So I don't know if the state would have a leg to stand on in reviewing that specific situation. Perhaps the Commission of Inquiry would be the correct people to take the matter on review. John
Steenhuisen, you believe this was the correct decision by the Department of Correctional Services to, I suppose, prioritize here the right to human dignity of former President Jacob Zuma, as he's terminally ill and in a position not to be able to self-care, that he be granted this medical parole?
Well, I don't think there's nearly enough transparency around to make a call. And if one looks at the history and the way in which the Shabir Sheikh matter was handled, I think a pattern is starting to develop here. There have been many applications from prisoners who are terminally ill that have been turned down, and it's a bit ironic that in this case has obviously been prioritized. And I would say that this points to a political decision rather than a medical decision. Section 79 was amended actually post the Sheikh experience to toughen up the way in which these assessments are made, and it requires the minister to have an independent medical board to advise him on whether this is the case. If they're relying on Mr. Zuma's own medical team's reports, I would venture that that is completely insufficient, that there needs to be an independent board. We know that Mr. Zuma was reluctant to submit himself to independent medical inquiry, and therefore we will be asking in Parliament, as well as through a PI application, whether this section of the legislation was complied with, and whether it was properly implemented. I think that they need to get Mr. Zuma out of jail for the elections coming up in 7 weeks' time. I think this is a political decision, and I only wish the president had the backbone to do a presidential pardon rather than to try and, what I would submit is, attempt a Shabir Sheikh episode where the medical parole is now being used as the excuse.
According to the Zuma Foundation, this was a medical examination conducted by the military doctors as well as the correctional services doctors. So two opinions that agreed on this particular one. I suppose the military doctors are the same doctors that all presidents use in this country. Do we have any reason why we should doubt their report?
Well, you have to have an independent medical board that makes the decision. It's not just up to the commissioner. It's got to be advised by an independent medical board. So that documentation should have been sent to the board. That board should have then appointed an independent medical inquiry to conduct, to ensure that it is actually, that is the case, and sent through. But what muddies the waters here even more is that we all know who the National Commissioner of Correctional Services is. It's Arthur Fraser. He's the very man who was Jacob Zuma's spy master during all those years and protected, defended, and subverted the state to protect Mr. Zuma and his allies. And obviously the president never had the backbone to sack him, and so he was moved into correctional services. And he actually is the commissioner that has made the decision in this regard, which I would have thought would have demanded a greater care of transparency that we don't have. And Mr. Fraser's connections with Mr. Zuma and their mutually beneficial relationship, I think, is problematic in this matter. And I would have hoped that either Mr. Fraser, obviously followed the law to the letter so that he can justify it. But certainly, if I was Mr. Fraser, I would have conducted this with a great deal level more transparency, because the obvious way it looks is that this is a political favor and decision that's been done to suit the political imperative of the ANC rather than uphold the correctional code.
Dr. Bloom, do you think medical parole, considering how it's really underutilized in the Department of Correctional Services, has opened an avenue for politically connected elite seeking to avoid imprisonment to abuse it?
Good evening, Thabo, and the viewers. You see, Thabo, let me take you back to say that when I was the chairperson of the Portfolio Committee on Correctional Services, many people have applied for parole, medical parole, that was critically ill. Some of them even died in prison. I don't hear about these things. I had experience of it. Now, this thing of Zuma is clearly a preferential treatment that Zuma received from his friends in correctional services. We will ask the Minister of Correctional Services, Ronald Lamola, and the Commissioner, Arthur Fraser, to come to Parliament and to explain. You see, Ronald Lamola, the minister, was telling and assuring the country that he will make sure that Zuma must not receive any preferential treatment there in front of Escort prison. He said so. Now, look what is happening now. This is plain. If it is not preferential treatment, why are they not releasing critically ill inmates that is sitting there. I'm saying, Thabo, I don't hear about these things. I worked with this in my oversight duties. Many inmates were complaining, and I visited them in prison, and I could see that this is the last days of this person's life. But correctional service have refused them to be placed on medical parole. So this is a disgrace. It's disgusting that our country, the parole system must be abused like this by ANC members. This is nothing else but politics, nothing else, Thabo.
Let's leave it there for tonight. I appreciate your reaction. Nthabiseng Dubazana, John Steenhuisen, and Dennis Bloom with us tonight, reacting to the news of the medical parole being granted to former President Jacob Zuma. DA going to ask for that information via the PIA Act, so expecting some more legal battles there.